Thank you, everybody, for bearing with us just as we got ourselves organised, and it's great to see such a turnout this evening. My name is Catherine Conlon. I am the head of school at the School of Social Work and Social Policy here at Trinity College. It's always a really special occasion for our Faculty of Arts, Humanities and Social Sciences to host the inaugural lecture of a newly appointed professor to the faculty. And so on behalf of the Dean, I welcome you all here for this wonderful celebratory occasion of the inaugural lecture by our own Professor Nicola Carr, Professor of Social Work and Social Policy in the School of Social Work and Social Policy. We're joined this evening by our Provost, Linda Doyle, by college officers, the Dean of Research, Sinead Ryan, and Senior Dean Owen O'Sullivan, and by Emeritus Professor of this of Social Work and Social Policy, Robbie Gilligan. Most especially, though, we welcome Nicola's family. Phil, her mum is here, her brother Colin, and Nicola's partner Annette. So I think every academic knows that you need a lot of distraction and support and help and assistance in retaining your sanity. And Nicola has plenty of that. And in particular from her dogs, Casper and Tova, who I think deserve a mention, even if they're not allowed onto campus today. We're also delighted to welcome friends of Nicola's who've travelled from Belfast and from Dublin, and for the women from Cork who travelled yesterday just to be sure that they would make it on time. Nicola's friends and colleagues also join us from Queen's University Belfast, from University of Liverpool, Southeastern Technological University and Maynooth University, as well as colleagues here from Trinity College, staff and students. And so we're really particularly delighted to see our students who in our school we do feel are particularly kind of committed and engaged in the school. So thank you all for turning out this evening. For me to welcome Nicola is particularly special because I've been head of school since Nicola joined us last October. It was, for me, an incredibly enriching addition to our school. Nicola's, hit the ground running. I know the Provost said, I haven't seen much of you since the interview, but that's because Nicola's had head down and been very busy and has been contributing enormously to the school already since she has joined. She is a warm, inspiring, committed, collegial colleague who will always drop in for a coffee and a distraction as well, which is always really, really welcome. We can't be serious all of the time. So then about Nicola. Nicola is an internationally recognised scholar in the fields of probation, youth justice and criminal justice policy. Her journey to professor this evening started with a degree in community justice and a diploma in probation studies in the University of Hertfordshire in 2001. And from there, Nicola went into practice as a probation officer in London, returning to Dublin in 2004. And then Nicola joined the Children's Acts Advisory Board, during which time she came to study here in the postgraduate diploma in child protection and welfare with Professor Stephanie Holt. And that was in 2005. And you got hooked back into academia then, Nicola, and embarked on a PhD entitled Child Detention in the Republic of Ireland under the supervision of Professor Owen O'Sullivan. And during the time as your doctoral research work, you were a research fellow in the Children's Research Centre with your partner in crime, Dr. Paula Mayock. And you then left us to join Queen's University Belfast between 2009 and 2017, and then on to the University of Nottingham, and became Professor in Criminology there in 2002. And throughout that time, your practice background has continued to inform your academic work. Nicola's research focuses on the experiences of individuals and communities in contact with the criminal justice system. She's undertaken significant studies on probation practice, professional decision-making and wider criminal justice reforms. Her work has been supported by leading research funders such as the Economic and Social Research Council, the Leverhulme Trust, the Nuffield Foundation, the British Academy and the EU, as well as governmental and non-governmental organisations. And currently Nicola is leading a major comparative study examining community supervision across 5 countries. Nicola has published widely on penal policy, rehabilitation, youth justice and the lived experience of justice. Her contributions extend beyond academia through media engagement, public debate and an award-winning documentary that won the New York Festival Radio Awards for RTE Documentary on One, for a documentary that was beautifully crafted telling the story of her mother Phil's family. Tonight, Nicola's inaugural lecture is entitled Doing Time, Rationalities, Practices and Experiences of Punishment. And in it, Nicola is drawn from across her career on research conducted with practitioners and individuals who have experienced the criminal justice system to explore how punishment is enacted and understood in everyday contexts. In particular, she is engaging with time, how time structures the penal process from the duration of sentences to the ways individuals to the process of rehabilitation and to the ways individuals are expected to demonstrate change. And also how time shapes how professionals understand their practice and how people serving sentences make sense of themselves, their past and their futures. So please join me in welcoming Nicola to present her inaugural lecture this evening. Thank you very much, Catherine, and thank you all for coming here this evening. I was going to say the last time I was dressed like this was as an altar girl in Knockline in the 1990s, but this is a more secular audience, I'm sure. Anyway, so thank you. Welcome to everybody who's come here this evening. I really appreciate you coming out for the start of the Christmas season, and thank you, Catherine, for your generous introduction. So, as Catherine said, my inaugural lecture is called Doing Time. In the late 1990s, I responded to a newspaper ad recruiting for a paid degree to train as a probation officer. The course and the job sounded intriguing, but I have to admit that a large part of the attraction was that our university fees were paid and we received a salary during our traineeship. After a selection process, I ended up as a trainee probation officer working in Willesden Probation Office in northwest London. The office, a squat red brick building, neighboured the grander imposing magistrates' court, where each day a stream of people, victims, defendants, witnesses, legal personnel, and members of the public processed through. Cases disposed, justice administered. Some of these cases were sent next door to the probation office to undertake a probation order or community service. Some were sent to prison, and depending on the sentence length, we then had to work to prepare people for release back into the community. In these instances, I travelled to meet people in prisons across the country and interviewed them in the cold confines of professional visit rooms in prisons such as HMP Feltham, Wormwood Scrubs and Strangeways. In this way, I got to tour England on a carceral circuit that unsurprisingly does not feature in many travel compendiums. Casting my mind back to that younger self, as much as it is ever possible to do so, at the time I was certain that it was possible to parse the evidence, to hear a person's account of what had led them to sitting in front of me, to interrogate their level of remorse, assess their insight into their offending, their recognition of the harm they'd caused, and the extent to which they demonstrated empathy with their victim. And in so doing, to formulate this into a report with a beginning, a middle, and an end. The ABC of antecedent, behaviour, and consequence, drawing on the evidence and logics of risk. Setting a narrative down on a page in chronological order, creating a subject. The end goal was to chart a terrain through which a different story was possible, not one in which the past could be erased, but where the future could be different. And this is me speaking at that graduation class back in over 20 years ago.
There's a story told by Polish about a young general in the First World War sending his troops off into the Alps on a reconnaissance mission. After they set out, the weather deteriorates, and 2 days later the soldiers have failed to return. The general is sure that he sent the illiterate men to their deaths. However, as he resigned himself to this, and in the throes of his depression, he spotted them returning, frozen and malnourished, a map in their hands. They tell him that they've survived because they held tough, and once the weather settles, they use a map to chart their way to safety. Overwhelmed with delight, he looks at the one paper and discovers that it is a map, not of the Alps, but of the Pyrenees. This is in some respects a part of our training. And the work that we do. The journey we make to inhospitable territory without grid references to identify a safe route or easy solutions. Because at the end of the day, whatever present governments or opposition to reductionist philosophies may try to suggest, what we deal with are people and the implications of people's actions. And this is not...
So, delivering an inaugural lecture this evening prompts a reflection both about a journey, yes, one without a map, in which I've travelled from practice into academia,
but also about the passage of time. It also connects to the theme on which I will focus on in this lecture, time and punishment, the intersections of which I've become increasingly interested in recent years. I want to say at this point that the work and the themes I will draw on this evening are the product of work that has also involved the labour of lots of other people whom I have had the privilege to work with, some of whom are here this evening, and I'm delighted to see you. I also want to acknowledge the research participants who have given their time to participate in research and share their stories. It has been and remains a great privilege to be able to do the kind of research that I've been able to do. The interrelationships between time and punishment that I will focus on this evening is not just about the experience of time passing, but also what it means to do time and how different rationalities of time in conceptions of punishment and its enactment serve to shape the experience of those involved in the criminal justice system. Time structures the penal process, from the duration of sentences to processes of rehabilitation to the ways individuals are expected to demonstrate change. Time also shapes how professionals understand their practice and how people serving sentences make sense of themselves, their past and their futures. When, for instance, is a person considered rehabilitated? How should the passing of time be felt, used or endured when serving punishment? In this evening's lecture, by drawing on research I've undertaken on different aspects of the criminal justice system, and by foregrounding time as a central organising principle, I will highlight time's constitutive role in shaping experiences, identities, and the lived realities of punishment. In terms of expectations, in one way, time is a taken-for-granted aspect of punishment within the criminal justice system. We are all familiar with the colloquialisms, such as doing time, to describe serving a prison sentence. Nearly every week we hear news stories critical of the length of sentence imposed by the courts. Almost never that a sentence is too long, but frequently that the length of a sentence is considered to be too short. In this way, we see that there are some common conceptions about time as a quantum of punishment, the sense in which a period of time should match the degree of harm caused by an offence. However, paradoxically, this is also often underscored by a recognition that time as a metric of punishment is insufficient. For some, and in some cases, no amount of time is considered to be enough. However, despite this common currency of time, time itself remains something of a backdrop or container in which we project our understandings and concepts of punishment. In other words, despite its ubiquity in our vernacular, time remains a relatively underexplored dimension of punishment. What does it in fact mean to do time? How can we think about time and punishment beyond the frame of the prison? And how are experiences and practices of punishment in the criminal justice system shaped by time? If we think more widely about the purposes of punishment, the penal rationalities or moral justification for imposing sentences, whether that be retribution, rehabilitation, deterrence, reparation, or incapacitation, we see that the concepts of time feature in each of these rationales, some more prominently than others. For retribution, the idea that the punishment imposed should be commensurate with the harm caused is measured in units of time. The quantum is the key issue. Punishment should be meted out in proportion to the degree of wrong. How much time should a person spend in prison? In this context, time is understood as a resource which a person may be deprived of by the state in proportion to their wrongdoing. When a person loses or is deprived of their liberty, this entails liberty to spend time doing what they would wish, where and with whom they would wish to do it with. Hence the expression doing or serving time has been characterised as the conventional temporalisation of criminal punishment. Incapacitation, on the other hand, implies time out from society, offering protection from potential harm for a specified or sometimes indeterminate period. Rehabilitation, the idea that the purpose of a sentence should be to support change from offending behaviour to a crime-free self, is also imbued with the concept of time. It implies a narrative arc from wrongdoer to upright citizen, a change that must take place over time. Meanwhile, deterrence theory, which rests on the idea that the imposition of criminal punishment is justified on the basis that it will deter future wrongdoing, both by the offender themselves and the wider public who observe the fact that the wrongdoing has consequences, also features temporal dimensions. In deterrence theory, the celerity of punishment is prized, alongside its certainty and severity. The assumption here is that the swiftness of the imposition of punishment is important, and that the more promptly and the more closely punishment follows upon the commission of crime, the more just and useful it will be. Underscoring this idea, as with all consequentialist philosophies of punishment, is the understanding that the consequences of punishment, i.e. what happens in future, matters. In this sense, we see both a looking backwards to the offence and the harm caused, and a looking forward to what may or may not happen in the future. This is also true of reparation, a further justification for imposing a criminal sentence, which signifies making up for harm and may entail giving of one's time to a victim or the wider community. And more broadly for restorative justice, which is based on fundamental ideas of the possibility of remediating harms as far as this is possible, caused in the past through the involvement in dialogue and agreement by those most affected, and which therefore has been characterised as a means to think forward through the past. Time is also a feature of the criminal justice process. Time is duration, the time taken from the commission of an offence to reporting, investigation, the decision to prosecute, court proceedings, and the eventual outcome. We're all familiar with the adage, justice delayed is justice denied, which suggests an imperative that the process should be swift. The attrition of evidence over time and the sense in which the further away from the wrongdoing, the lesser the likelihood of achieving justice, is sometimes signified by legal time limits. Although, as we have seen in recent years, thanks to increased awareness and an exposure of the cultures of silence and complicity that were its enablers, more cases are coming before the courts relating to so-called historic sexual abuse, where the victim, now an adult, has been able to report abuse they experienced as children, and the perpetrator, often elderly, receives a sentence for the harm caused. Such cases raise profound questions about time, its passage, and the relationship to justice and the purposes and aims of punishment. The links between time, processes, and justice is also raised in questions concerning the relationship between individual actions and broader harms. Indeed, one of the key critiques of our current criminal justice system is that it is highly individualised, locating responsibility with individuals while broader systemic contributory factors are sidelined or ignored, or even more perniciously, when systems and cultures serve to protect institutions and individuals from accountability. Think, for instance, about the phenomenal work of Louise O'Keeffe, who was a victim of sexual abuse by a school principal when in primary school in the 1970s, and who has since been seeking to hold the Irish state accountable for its failure to adequately protect her and other children. 13 years ago, the European Court of Human Rights ruled that the Irish state was liable for sexual abuse suffered by O'Keeffe. However, the state has still not fully implemented the recommendations following from this judgment. Or, if we look across the border at the years of stymied, protracted, and ultimately failed processes to apportion accountability for the murders of 26 unarmed civilians during a protest march in Derry on the 30th of January 1972, otherwise Bloody Sunday. In October of this year, Soldier F, a former British paratrooper, was found not guilty of the murders of 2 of the victims, James Ray and William McKinney, and the attempted murder of 5 others, meaning that despite multiple inquiries, no one has ever been held criminally accountable for these killings. The processes of uncertainty and waiting is acutely felt by victims and all those involved in criminal proceedings. Despite imperatives to speed up processes, many find themselves living in these in-between spaces where time does not proceed in a linear fashion. Or, in the words of the poet Denise Riley, who has written movingly about experiences of time following the sudden death of her son, time is lived without its flow, joined in non-time and halted in free fall. An experience she describes as an acute sensation of being cut off from conventional temporal orderings. The sense that time does not move as it should, not merely that it is arrested or stopped, but as she describes it, that one has been lifted clear out of habitual time. This insight tells us something both of the fact that we often experience time as movement, as something inexorable, but also that our conceptions of time are bound to ideas of the way things should proceed. It also directs attention to the fact that we can all simultaneously experience time differently, as I'm sure many of you are here this evening, including myself. People experience criminal justice processes differently depending on a number of factors, including their role within it, the nature of the offence and the harm caused, the stage of the process and their wider life experiences. To wait for a case to complete obviously has different implications viewed from these different perspectives. Focusing in now on just one aspect of the process, the time between adjudication, a finding of guilt and sentence, helps to illuminate this. In research I undertook with Dr. Niamh Maguire, looking at the practices and processes in relation to the preparation of pre-sentence reports and their use by the courts in Ireland, we explore this aspect of the criminal process from the perspective of the range of actors involved. The judiciary who had requested the reports, the probation officers who prepared and wrote them, and the people who were the subject of the reports. This research, which was supported and facilitated by the probation service, and great to see the people who supported the research here tonight, took as one of its starting points the fact that there is a sporadic use of both pre-sentence reports and community sentences in Ireland, evidenced by this map from the Probation Service's most recent annual report, which shows referrals to the Probation Service based on a rate of every 100,000 people. We see, for instance, that in Wexford there is a low rate of referral, less than 50 people per 100,000, while in Limerick it is much higher, more than 300 people per 100,000. There's no evident reason for these discrepancies. We were therefore interested in looking at why there were these differences in uptake and what were the potential implications for access to justice. So just to explain, pre-sentence reports are reports which can be requested by a judge following a plea or a finding of guilt and prior to the final sentencing decision. The reports are prepared by the Probation Service and require a probation officer to meet with the defendant, usually on a number of occasions, to carry out interviews and draw on wider background information, including prior criminal records, the evidence presented in the case, and information from other professionals, such as drug and alcohol services. The reports themselves follow a standard format, which includes sections on the person's background, a section containing an analysis of an offence, and this includes a description of the defendant's own account and understanding of what has occurred. It is also intended to explore the extent to which the person shows insight into the harms caused to any victims. The report will then present an analysis of risk of reoffending and risk of harm. And based on all of this information, we will conclude with a proposal to the court regarding possible sentencing options. We were also interested in the congruence between these proposals and the judge's ultimate sentencing decisions. While these initial research questions, when do judges request pre-sentence reports, how are they constructed, and do the reports impact sentencing decisions, were what prompted the study, the process of undertaking the research also brought the issue of time to the fore. And that's one of the privileges of doing research. You often see things that you hadn't anticipated or that the research data makes you think about in different ways. In this case, this was in part prompted by one of the challenges of undertaking the study. We had designed the research to involve a number of elements: observation in court to see the circumstances in which reports were requested, observations of the report interview process. This meant sitting in on interviews to observe the report's interviews taking place, analysis of the final reports submitted to the court, and follow-up interviews with all involved. In order not to disrupt proceedings in any way, our research design specified that we would carry out follow-up interviews after the court process had been finalised, i.e. when the sentence was passed. However, what soon became apparent to us was the fact that the process between report request and eventual outcome was for many a very protracted process. Some of the cases in our sample took over a year to finalise. And this was for multiple reasons, including the fact that gathering information for reports took time. Some people missed appointments for their interviews and the proceedings were subsequently adjourned to allow for further opportunities to attend. In some instances, judges received completed reports and based on the information therein, decided to adjourn sentencing to see how the person got on in some of the areas they were making progress in their lives before they finally decided on the sentence they would impose. This practice of adjourned supervision has been described as an innovation by the Irish judiciary in the absence of a specific legislative basis for the practice. I should also note that the Probation of Offenders Act 1907 remains the primary legislative basis for probation in Ireland, despite the fact that there have been multiple commitments by governments over the years to update the legislation. Another interesting aspect of temporality that I won't get into this evening. Why these processes were so long and what it means for someone to be in this in-between time therefore became an area of focus. In interviews with judges, we explored what they were seeking to achieve when they requested a pre-sentence report, which, as noted, is a variable practice in courts across the country. If you've ever been to a district court, you will know that the processes move very quickly. There is an imperative to get through the court lists and to complete the business of the day. This is something that students are often surprised by when we visit a criminal court for the first time. Many of us have these preconceived ideas from television and film that courts are places of deliberation and careful back and forth argumentation. This can, of course, be the case, but most often in the district courts, where all criminal cases start and where most are completed, the proceedings are quick and perfunctory. The parties most intimately involved, victims and defendants, rarely get to speak to them for themselves. Their perspectives are voiced through interlocutors, or in the case of victims, sometimes not at all. The term summary justice is used to refer to these proceedings, which provides an indication of both the process and the pace. So when we asked judges in what circumstances they would pause to request a report, there was a recognition that with the speed of regular court proceedings, there was not time to look into the background of the person being sentenced. Therefore, some saw this as an opportunity to refer the person to the probation service as a means to take this time to look into the background. As this judge explains, yes, well, the court process is so fast and you don't have time. And equally, you can't just impose a sentence in a bubble when you know in your heart and soul that there is a reason for this offending, and if you can get to the reason, the probation service, they have the time to look into the background. We drew on Mariana Valverde's concept of a chronotope to explain this shift in spatio-temporal logics from the speed of court setting towards the different spatio-temporal order of probation time in the community, to describe the move of the defendant from one jurisdiction, which is to say, from one site of governance, to another. In this way, it is also interesting to see how the subject of supervision is created along temporal dimensions within pre-sentence report. The act of writing a report creates a biographical subject, a person with a past, present, and envisaged future. There is the person of the time before the offence, sometimes with a prior offending history stretching back over time. The reasons for this offending have to be accounted for and explained, and the consideration of risk, which is in essence an envisaging of the future, has to be laid out. And in such a way, we can think about risk as a way of trying to foretell or take hold of the future. If a sentence in the community on probation is recommended, then the person described in the report has to be envisioned as what Kelly Hannah Moffat, the Canadian criminologist, describes as a transformative risk subject. That is, a person amenable to intervention into the future. We see this characterization in these extracts from a pre-sentence report, obviously not the people's real name, for a person before the court for offences of theft and for whom a community sentence is recommended. The report author states, "It is my view that Mr. Delaney would benefit from a further period of probation supervision." When laying the ground for this recommendation, we see too that the potential for progress is described in temporal terms. It appears that he progressed well while he was previously in the community and responded well to routine and structure in his life. The report continues, "The offence before the court today occurred at a time of having no daily occupation or structure as his period of supervision had ended. Mr. Delaney has commenced addressing his risk factors by commencing an alcohol detox and could benefit from the support of this service and addiction services to complete this programme." The contingent nature of this imagined future is recognised by the phrase, "This process is at a tentative stage given his addiction history." For some judges then, the pausing of summary court proceedings to allow for the probation service to inquire into the background of a person and to produce a report provides a means to shift temporal register. This judge describes their rationale for doing so. If it gets the punter out of the system, that's what you want. You don't want to punish someone. You want to get them to repay society in some way, but then get them out of the system. You can punish them by a fine and by imprisonment, but does that cure the problem? I don't necessarily think it does, because you get them back again. What you want to do is find out why they're offending and try to get them away from that. But the process of stopping the criminal court clock through adjournment in order to prepare a pre-sentence report does not mean that the person is free. In fact, in the period before sentence, they are essentially in limbo and yet still subject to oversight, as another judge describes it. If you were adjourning the matter for a probation report, unofficially, you're giving that person an extra piece of leash to use the probation service as an assist in getting themselves detoxified or stabilised in terms of their accommodation and so forth. This extra piece of leash, which the temporal shift affords, and which, as the image of the leash vividly conveys, affords a constrained freedom, but this is clearly under a regime of governance and control. This research on pre-census reports tells us something about the potential temporal ordering to both change the nature of governance and to construct the subject of punishment in a particular way. But what of the experience of people subject to the justice system? How do they experience governance in time? In many countries, the number of people subject to supervision in the community far exceeds numbers in prison. In Ireland, on any given day, there are roughly twice as many people subject to supervision in the community as a result of a criminal sentence than there are in prison. This observation is not intended in any way to underplay the fact that the prison population is rising, which I'm sure we've heard in recent news coverage is a matter of urgent concern, but rather to note that we have far less knowledge about other aspects of the criminal justice system. The lion's share of criminological research has focused on prisons and experiences of imprisonment, while there has been much less research on other forms of sentences and punishment. There are a number of reasons for this. Firstly, imprisonment is the most severe sanction that courts can impose, and therefore it warrants research and particular ethical consideration. Secondly, other forms of sanction, whether that be a fine or a community sentence, such as a probation order, are much less visible. Prisons are replete with iconography. One can readily conjure up an image of a prison cell, but you'd perhaps be more hard-pressed to picture a probation office. Some of the most well-known research on imprisonment and experiences of imprisonment, as well as prisoner biographies, convey the ways in which time is regulated and managed in prison. In his book, Discipline and Punish, which charts the move from the physical forms of punishment to the modern penitentiary, Michel Foucault famously describes the regime in Maître Reformatory School, which he considered to be the apogee of the modern regime of punishment. Each hour of the day accounted for in the regular chronologies of a schedule, which was aimed to inculcate discipline in the lives of the young people detained and put to work there. While Gresham Sykes, in his groundbreaking study, The Society of Captives, which explores experiences of imprisonment, describes the loss of autonomy exemplified by the inability to control one's own schedule as one of the additional pains of imprisonment. That is additional to the pain of loss of liberty itself. While being subject to a community sentence evidently does not involve the same loss of liberty in this sense, it does, as noted earlier, involve the imposition of requirements and restrictions, sometimes for significant periods of time. Moreover, it is freighted with the expectation that people should become rehabilitated. With this in mind, recent research, which I'm leading with colleagues in the University of Strathclyde, Stirling, Glasgow, Cambridge and Nottingham, is exploring the experiences of people subject to supervision in the community. It's a comparative study across 5 nations: England, the Republic of Ireland, Northern Ireland, Scotland and Wales, and it involves a number of elements, including a digital ethnography with people under supervision and with practitioners, and then follow-up interviews where we explore their perspectives. Using these methods, we're trying to get at the day-to-day realities of life under supervision. And unsurprisingly, themes of temporality surface in different ways. For the digital ethnographic part of the research, we asked participants to upload comments, videos, or images onto a secure site over the course of 3 weeks in response to prompts such as the following for people under supervision. How would you sum up your experience of probation supervision so far? Does being on an order or a license make any difference to your relationships with families and friends? What things do you have to do as part of your order? How do you feel about being on your order? And a set of parallel questions for practitioners. What's it like being a probation officer? How do you think being on a license affects the people you supervise? How do you spend your working day? The responses to these prompts are multiple, but I just want to provide you with some insights into the data generated, which speaks to these senses of multiple temporalities. In this response, Richard, again not his real name, took a picture of this ornament of an astronaut. He said that this conveyed to him the feeling of sometimes being lost, like an astronaut that was lost in space, floating and unsure. I'm uncertain about my future, and I fear this quite a bit at times, capturing his sense of a life in limbo. Here, Alan, not his real name, in response to the question, what is the impact of being on an order or license, is reflecting on his life so far, how he sees the future and the steps he wants to take to get there. He says, I'm on probation, but this is not the end. It's my second chance. Every day I stay focused, follow my conditions and make good choices. I prove to myself that I can move forward. This time in my life is about rebuilding trust, growing stronger, and creating a better path. He is envisaging something better, and no doubt we would see this as rehabilitative. But we can also feel the weight of the expectation in the words he uses: to rebuild, to grow stronger, to overcome the challenge, one step at a time. This is from Fiona, again not her real name, who's taken this image of a quote she finds meaningful in response to a question asking her to describe what it's like being under supervision. She says, "This is my favourite quote and one of the things I like to tell myself when thinking about past mistakes, situations, or when I'm feeling low. For many years, this quote has given me strength and a new blank page to restart whenever needed." The reference to the past invokes temporality, but again it is freighted with a sense of shame, a burden, a requirement to turn a page, to live life differently. And any of us, all of us, who've tried to change anything in our lives will know that these are not simple or straightforward matters. Change can be painful. This temporality is recognised by practitioners also. This image and response generated by John, a practitioner, to the prompt, "Can you share an image which captures the relationship you have with clients?" Provides this picture of trees, and his explanation provides a vivid sense of the temporal movement that being under supervision involves. He says, "Sometimes I find weathers and seasons have an impact on people, such as people suffering with depression can find darker evenings coming difficult, or others feel more isolated in winter and drink alcohol more. So this can be a useful topic at times." He goes on to say, "During supervision sessions, a lot of difficult topics are discussed, such as the client's own past traumas, their offending, the impact they've had on victims. Consciously, when the session is coming to a close, I start recapping on what we discussed and making a plan for the next steps. Then again, I would go back to topics such as what it's like outside, what plans they have for the day, while I walk back to the door. I find this helps bring them back to the present before they leave." This reference to changing seasons signifies the passage of time, but also the sense in which what is talked about in supervision entails a return to painful matters, the time of the offence and what preceded it. This is recognised here by the fact that part of the ending of the supervisory meeting involves walking the person to the door to help bring them back to the present before they leave. These responses are just one small part of an overall project which is ongoing, but they provide some indication of the temporal dimensions, including the different lived experiences of time and its restrictions, while being subject to supervision in the community. However, if rehabilitation, as these examples show, is freighted with an expectation and weight that a focus and temporality can help illuminate, it is also useful to think about what happens to people when their formal punishment has ended, in what we might call the afterlife of punishment. At what point do we consider people to have served their sentence? The straightforward answer is when the sentence period has ended. However, we know that people who have a criminal record often face multiple obstacles when moving on from their offending, a subject that featured recently in our recent presidential election. The temporal burden of criminal records can include the expectation that individuals repeatedly revisit their past. However, if we're serious about the possibility that people can leave offending behind, then we need to think about the ways in which a person's criminal record, a record of past behaviour, hangs over their prospects into the future, following them across time, shaping opportunities and identities, many years after people's contact with the criminal justice system has formally ended. So, to conclude, you'd be glad to know, to understand criminal justice through the lens of time is to see its complexity. It reveals how punishment is simultaneously backward-looking, concerned with what has been done, and forward-looking, concerned with who a person might become. It shows how the system relies on time as a currency, sentences measured in months and years, progress charted across weeks and appointments, futures forecast through risk assessments. Yet it also exposes the inadequacies of time as a metric. More importantly, this temporal lens brings into focus the lived experiences of those within the system. For people waiting between conviction and sentence, time stretches into uncertainty. For those serving a prison term, time may be regimented, controlled, and often painfully stagnant. For individuals under community supervision, time becomes something they must account for, past missteps revisited, future choices scrutinised, present moments weighed with expectations of progress. What we routinely call rehabilitation is in practice an invitation, sometimes a demand, to restoring one's life, to reorder its temporalities, and that work can be profoundly difficult. Time also marks the system's own failures. The decades-long wait for accountability in cases of institutional abuse or historical injustices expose the fragility of our faith in justice as something that can arrive in time. The protracted limbo of court delays, the slow or stalled implementation of legal rulings, and the enduring aftermath of punishment all remind us that the temporalities of justice and punishment are multiple and experienced differently. I hope I've shown how time shapes how justice is delivered, how it is felt, and how it is endured. Delivering a lecture of this nature also involves setting down a narrative arc. As I noted, I began my professional career imagining that the work of justice could be organised into orderly narratives of antecedent behaviour and consequence, a beginning, a middle, and an end. However, I would like to think that even then I had the sense to know that all stories are contingent, with different restoried pasts, reimagined presents, and possible futures. Thank you.
Thank you, Nicola, for, as you say, giving us all those different multiple dimensions of time and perspectives.